Good afternoon. My name is Kenny Fox. I'm the chairman of the Animal ID Committee, and it's my privilege to introduce you to Kara Rollins. She's our attorney, and she serves as the litigation counsel for New Civil Liberties Alliance. Before joining NCLA, Kara Rollins was counsel for Cause of Action Institute, where she represented clients in various federal trade commission enforcement actions. She also engaged in strategic research and oversight of executive branch agencies, focusing on administrative rulemaking and government oversight and compliance. Prior to joining the Cause of Action Institute in 2016, she clerked for the Honorable Karen M. Cassidy, AJSC, in the Superior Court of New Jersey, Union Vicinage. Preceding her legal career, Rollins served as political programs manager for the National Federation of Independent Business, where she worked with small business owners throughout the country and learned firsthand about the adverse impacts the regulatory state has on individuals. Rollins graduated with honors from Rutgers College, Rutgers University, with a BA in Political Science in 2007 and cum laude from Catholic University, Columbus School of Law in 2014. Please welcome Kara, and she will explain what's going on with this lawsuit that we have against USDA and the administrative procedures, the rule on the ear tag mandate.
Thank you, Kenny. And it's always a pleasure to be back here. As you can tell from my bio, I'm from out east. I don't mean Sioux Falls, but I am West River, South Dakota by marriage. So it's always happy to be back here in the hills amongst, folks like Kenny and Bill and all y'all just doing the hard work, making sure we have food on our tables. And so we'll see. I put together a presentation. Maybe it'll work, maybe it won't. Oh, there it goes. So first off, about NCLA, we are a nonprofit pro bono legal services organization founded by Philip Hamburger. He's a legal scholar from Columbia University. And our focus is on protecting constitutional freedoms from violations by the administrative state. As you can imagine, they need 50 of me at any given time back in DC, because the administrative state, despite wins, as the professor mentioned, we had the companion case, Relentless. That's the companion case to Loper Bright. We represented the other group of fishermen in that case. So even when we win things like overturning Chevron deference, the thing about bureaucratic inertia is it just keeps rolling forward. So our emphasis is always on this idea of we want to let judges judge, we want to let legislators legislate, and we want to stop bureaucrats from doing either. We want to restore the original order as set out by the Constitution. Before I kick this off too far, I just want to say that, this is classic lawyer, all views expressed herein are my own. They do not necessarily represent the views of NCLA or any other individual or organization. I want to start off with a thank you to Bill, thank you to RCAF, its members, thank you to Kenny and Roxy Fox, Rick and Teresa Fox, as well as the South Dakota Stock Growers and the Farm and Ranch Freedom Alliance, who are all serving as plaintiffs in this matter. We can't do the work that we do at NCLA to hold the government to account if we don't have people who are willing to step up, and we know how difficult that is, particularly when it's against the folks who regulate you. I know some of you have been in this fight for a long time. Kenny's been in it for a long time. I like to joke, since we're here in Deadwood, this idea of tagging all cattle with RFID is probably able to legally gamble now. It's been going on about 20 some odd years, starting in 2002 when Congress passed the Animal Health Protection Act. Didn't take long for APHIS and USDA to then implement what we'll call the National Animal Identification System. This is NACE. This is the predecessor to the 2013 ADT rule. That NACE system initially called for voluntary but full RFID cattle tagging or using microchipping. And that was a birth to grave system that they were calling for. In classic government fashion, what they couldn't do, say, by mandate, they encouraged with money. So there were some states that received grants from USDA, and they implemented what I would say are more mandatory versions of the program. What that comes out to then is it actually gives us a lot of good data that we're relying on in some ways in this case to show the ways that sort of hurts producers, because we know what happens when these programs are implemented in the states. 2010, then Secretary Vilsack, we'll hear his name again very shortly, ends up withdrawing the NACE plan, and that's the credit to producers and groups like RCAF who came out and said, absolutely not, we are not putting this on our people. They shouldn't have to carry the financial burden of this. And USDA at that time backed off. Again, I mentioned at the outset of this, bureaucratic inertia, once the ball gets rolling, they really can't stop. And what we've seen through this process and this timeline shows is that despite clear objections by producers and the folks on the ground who have to foot the bill for this, that it just keeps rolling forward, that there's a handful of folks at USDA and APHIS or interested parties who just want to tag all cattle because maybe it's easier in some way. I want to be very clear, and this is something Kenny always reminds me of, is we have not had a major health outbreak in America's cattle. Again, that is a credit to the producers. It is a credit to the system that has been in place. We have one of the healthiest sets of cattle in the world, if not the healthiest. And so when you get these sort of mandates that come in, it's a bit of a head scratcher because we've been doing everything right and the current system worked. We move forward, 2013, this is the ADT, the Animal Disease Traceability Rule. This is the framework, this is all, pretty much if you can eat it or show it, that animal is covered by the ADT rule, but particularly for our interests, cattle and bison. This is the initial set of tagging for interstate movement as well as official identification. And so that works for a while, and then in April of 2019, without even saying anything, APHIS just put what we call a fact sheet online. Just shows up one day online saying, you need to tag your cattle with RFID. This is in direct contravention to the existing rule, done without notice and comment. At the time, Kenny, as well as some others and RCAF stepped up, and led by my dear friend and former colleague, now Congresswoman Harriet Hageman, we brought a challenge to that fact sheet. We said, you can't do this. You can't undo a rule that was passed with notice and comment just by publishing a fact sheet. And you know what happened? We filed that lawsuit. About 3 weeks later, fact sheet's gone. And they moved the case. And so, you know, I think that that's one of those things where it seemed to me at the time, it's one of the first cases I worked on when I joined NCLA, is that USDA and APHIS got their hand caught in the cookie jar, and they didn't want to answer for that. So fast forward to July of 2020, they try it again, and if you look at the time frames, it's identical to what they had proposed in the fact sheet, right? That idea of bureaucratic inertia, they just can't get away with it. It's a dog with a bone. They can't get away from this idea, we want to tag these cattle, and we're going to get there any means necessary. Again, outcry from producers, led by groups like RCAF, stock growers, Farmer Ranch Freedom Alliance. There's over 900 comments. Again, APHIS says, whoa, 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 we're not going to move forward with this at this time. If we do, we're going to do a rule. That's where we are now. January of 2023, they propose the APHIS EID rule. In the past, it was RFID. They now call it EID, this electronic identification. Surprise to no one, the only EIDs that exist on the market right now are RFIDs. So, you know, what they said is, well, we're going to leave it open that there might be other sorts of technology in the future, so we just want to call it electronic, not radio frequency. But it's a distinction without a difference right now. So May of 2024, EID rule is promulgated. And then in late October 2024, we file our lawsuit. The rule goes into effect on November 5th, 2024. And so what is this? And I'll tell you that tag on there, that is AI generated. The tags are much smaller. For many of you who've had to handle them, they're about the size of a quarter in comparison to some of the tags we've used in the past. But one of the most common sets of questions I get is, are my cattle covered? The question is, I don't necessarily know, because there are so many sort of nuances to how this rule works. And And there's just been a lot of confusion, and that's on USDA and APHIS, that there's confusion amongst producers because they haven't done a good job of communicating how this applies and when. So first off, if you tagged any of your cattle on or before November 4th, 2024, they are gonna get grandfathered in under the rule. You do not need to put a new RFID onto them unless somehow their existing tag falls off and you're tagging them again. In that case, you would have to put an RFID on if it fits, again, one of these scenarios. So, the ones that I think affects most folks in this room are the sexually intact cattle and bison 18 months or older. And then, some of these that are used for maybe if you're doing rodeo animals or shows and exhibits. I know that probably I saw some FFA folks out in the room. So for folks that are showing, they're gonna have to use these tags as well. We'll go back to this bangs tag issue because this has been a point of contention in the litigation, but effectively it eliminates the use of the visual only metal bangs tags, the orange tags. We know this for a handful of reasons, including that USDA, at least, and this is all sort of secondhand knowledge that comes to us over time, that USDA APHIS asked for the collection of any sort of leftover of those metal bangs tags to be sent back, presumably for destruction. So, there's none floating out there for folks to be using. And again, this only applies to tags that are placed on or after November 5th, 2024. So again, there's all these exemptions in the rule. The official identification for folks who are worried about this, it's the USDA official ear tag. It must be visually and electronically readable. In the past, it was visual or electronically readable. Now that's an and, it's gotta be both. Certain brands and certain breed associations, group and lot identification are permissible uses, but we tend to find, at least when we're out talking with independent producers, those aren't applicable to their scenarios, and I am seeing some head shaking, so I'm glad we got the read of that right. So we also have exemptions, so if your cattle, feeder calves under 18 months of age, direct to slaughter, ones that are gonna be held for less than 3 days, and importantly, cattle or bison that do not leave the state. For bigger producing states that have packing facilities, feedlots, all of that, this rule mostly doesn't apply to them, right? But for states like South Dakota, like Wyoming, I think North Dakota falls into this category too, where they don't have meat processing available in state, they don't have finishing lots, it's being borne by that subset of producers. When we're talking about the numbers, the nation's cattle herd is approximately 90 to 99 million head. This rule applies to roughly 11 million head, so it's about 10% of the herd. And I always get into enforcement because I saw it floating around the internet, and it was a come and tag it, and it was, folks are saying, come tag my cattle if you want. Please just remember that this rule, whether or not you agree with it, is enforced not just by civil penalties, but also by potential criminal penalties and fines and imprisonment for willful violations. And so I know most people in this room do not like this rule, they disagree with it, they do not think it is necessary, but please know that as of right now, it is the law and it can be, subject to pretty substantial fines. I believe the fines for civil are about $87,000, give or take, for a violation. And the criminal fines and penalties are about $250,000 up to 5 years in jail. And so I always make this point when people, come out and they ask me, well, what if I just don't tag? I'm not gonna answer that one way or another, but I'm gonna make you aware that there are pretty substantial penalties at play. So getting into the litigation, we talked about this earlier, we filed October 30th here in the District of South Dakota. And back in late January, USDA APHIS filed what we call a motion to dismiss. They made some claims, particularly that the parties did not have standing. They also made some sort of technical arguments about some of the positions we took in the complaint, and we went back and looked at it and said, well, we'll replead. So we filed an amended complaint that added more facts. We thought it satisfied certainly some of their standing problems, And they came back and said, no, we don't think so. So they filed a second motion to dismiss based on the amended complaint. Again, this is ongoing litigation, still in the fairly preliminary stages, so I want to be careful about what I can speak to. What I'm speaking to is what is already sort of public and summarized, and that I feel comfortable sort of giving our opinion without getting into confidential type issues or detailed strategy points. But the government what I want to focus on is the government's main thrust in this motion is that we don't have standing to maintain this. I think earlier we mentioned standing. For those that don't know, federal jurisdiction of cases and for courts is limited to what we call cases and controversies as outlined in the Constitution. Standing is the capacity to bring and maintain a suit. It's kind of made up of 3 factors, and we tend to call this, injury that's traceable to the defendant's actions, and is redressed by favorable government or a favorable outcome by the court. And there's a couple of nuances that come in there in the legal sense, but I think critically here, one of the things that left me scratching my head on the standing point that the government made is, as I just mentioned, this is civilly and criminally liable. And there is a softer touch in some ways, is that when something is enforceable in that way, when you have the possibility of a full-throated government prosecution for your actions, the injury prong is a little bit easier to meet. And so, we are sort of tussling on some of these points. USDA APHIS put out essentially 3 arguments against standing. And for any of you on blood pressure medicine or heart problems, feel free to walk away now because what I'm about to say might frustrate you a little bit. And the first is that, and this one was I'll say this one was just flat out wrong. They said, well, the plaintiffs aren't impacted by EID because they could use the other alternative methods. And we said, well, no, our guys, they rely on tags. And we had to explain to USDA and APHIS what the other exemptions were. They didn't seem to understand what a brand registration was, or what these other nuances were and why they weren't applicable to most producers. They also make the point that, and this is where we're going to get into it, because I think this is the one that's been most shocking and frustrating to me, is that they claim that the EID rule doesn't change the bangs vaccination process. So I'm guessing a lot of you in this rule, I'm seeing head shaking because you vaccinated your calves this spring, or you're about to vaccinate. The government sort of made the sense, well, you could still use the metal tags. You can't. It's right there in the rule. You can't do that. And when we pointed that out to them, their response was, well, at the end of the day, folks are deciding to bangs vaccinate. So it's a self-inflicted injury. And it's not enough to maintain standing. I think certainly for you is before this rule is in place, some of you have probably been ranching and raising for decades now, and you've been bangs vaccinating all along. You didn't choose this rule to come to you, the rule came to it, and I think that is a classic instance of injury. But importantly, we just think that the way the text of the rule is written, it obviously implicates bangs tags, as I mentioned earlier. It's our understanding that the metal tags that have been used have been collected and sent back to APHIS, potentially for destruction. That's a pretty strong signal to me that it's RFID and RFID only if you are using tags when you are doing vaccination. Critically for folks, if you are moving your cattle interstate, which is what triggers this in some ways, the bangs vaccination tag also serves that purpose. So whether you pay for it when it's a calf and you're bangs vaccinating, or 10 years down the line, you still got to put the tag in and you still have to pay for it. And so I think that there's just a lot of gaps in USDA APHIS's understanding of how most producers, particularly small and independent producers, run their herds, manage their herds, and do their business, which is alarming in its own way. On the bangs vaccination point, one of the things that makes this very laughable to me, at least, is that, when I said that 11 million cattle are affected by this each year, that's the government's own estimate, and it's based on at least 4 million cattle needing bangs tags. So even in their own calculations of what the cost of this rule is, it is based on the idea that bangs vaccination has changed and has changed the requirements of it. I think one of the frustrating things is when you looked at the government's response after the rule was promulgated, they also said, we don't think that this is going to reduce bangs vaccination. And now their sort of argument before court is, well, you can choose to bangs vaccinate or you could choose to pay a tag. And it just leaves you scratching your head because APHIS has already said, well, we don't think it's going to reduce it. Well, if you're given an either or choice, there's going to be some reduction. And critically, and I think that this is the most confusing part to me at least, is that one of the reasons we have hit near eradication of brucellosis is because we have vaccination, and is because folks like you in this room have excellent practices and do that work, and the veterinarians are out there doing their jobs as well. And so to now say, well, you don't really need to vaccinate, and justify this rule on the idea that we're trying to increase traceability and decrease disease is just one of those things that I can't hold both those thoughts in my head at the same time. But apparently that's sort of the position that USDA-APHIS is taking at this point. And finally, USDA-APHIS have claimed that our harms are too speculative. That's interesting because we did have folks who had to pay out of pocket to tag their cattle. And they said, well, why didn't you go find some of the free tags? As if you can take time away from your business running your cattle to call all the vets in your area to see if they magically got some of these tags. One of the things we know is there was never enough free tags. Government allotted about $15 million. The rule costs about $26.1 million a year. That puts them shy of about 60% of the total tags needed. So as a matter of basic math, there was never enough free tags. The government's come back now after we pointed that out to them and said, well, no, in December, we found a pool of money and it's fully funded for next year. I don't know about anybody in this room. Please come up to me after. I have not heard one person beyond what the government has said that has gotten free tags or that this is fully funded. And so, what happened after the transition, I can't tell you, but as of December, they seem to say that there was enough money to fully fund this. Where are we now? We'll be arguing this motion July 11th, and we'll be keeping you updated. I know Bill does regular updates. We always put our updates on our case page, so please go to our website. And I do have some time for questions, and I'm more than happy to answer them to the extent that I can.
Stayed in Weldon, Texas. At what time, at what age do these calves have to have this RFID tag?
So I think that answer is a little twofold. Is if you read to be an official Bangs calfhood vaccinate, the RFID tag would have to be placed when you do the vaccination. Now, if you're moving the cattle interstate, technically it doesn't need to be done until they're 18 months or older.
18 months or older.
Mm-hmm.
All right. If you are working calves and you have bulls there and you're going to cut them, do they have to have the RFID tag? Because you're going to be selling them through the auction. And from there, they might go interstate and they might not.
That one I can't answer. That's one of the more difficult questions. What we've heard sort of through the grapevine is that unfortunately the sale barns and the folks at the sale barns are having to answer a lot of these hard questions themselves for exactly that reason. You don't know when it gets on, when you're loading them up on your facility where they're going, do they need a tag or not? And so that's one of the more difficult questions that really is a case-by-case basis. But my understanding is the sale barns are sort of stepping in and having to make those calls as they're going through with it.
All right, now then, on your heifers, if you're raising them to be resold into a commercial herd, someone else's commercial herd, at the time that they're usually passed, they're all bangs vaccinated. At that time, when you're having them bangs vaccinated, or at the time that you would, do you have to put the RFID tag in at that time?
So if they're already bangs vaccinated and that tag was placed on or before November 4th, 2024, you do not have to put another RFID in. That's very clear in the rule. As your bangs vaccinating moving forward, The official definition has been modified to require a RFID tag when you bangs vaccinate after November 5th of 2024. So it might be in one herd a mixture, cattle that are cows that have already been vaccinated years ago and still have their metal clip tags, and then sort of this year's yearlings that need, tags put in when they're doing it. But it is really sort of case by case basis.
All right, thank you.
You're welcome.
I think I could clear up the first question that Staten asked. If I understand the rule right, it says all sexually intact cattle 18 months of age
Or older.
or older. So if you have a 2-year-old bull and and you want to castrate him, then he can go anywhere because he's not sexually intact.
Sexually intact cattle would have to have the RFID tag. Like heifers being sold, okay, I take my heifers to sales, special sales, and then they leave that sale, and I don't know where they're gonna go then. But they have to have the RFID tag.
If they're 18 months of age and older. If they're heifer calves, they don't have to have any kind of tag. Unless you bangs vaccinate them, then they're supposed to have the electronic ear tag. You bet.
I think Jaden's was like, are there more questions?
Who will enforce the $87,000 fine?
So the way it works now is APHIS does have enforcement power. That's the tricky question. We know under the 2013 ADT rule that there were a handful of times where fines were assessed by APHIS. But I think the tricky thing that we're hearing is that, the folks in the sale barns are the ones on some level, when the cattle are coming in, are the ones who are having to say, you got to put a tag in this cow, or bull, whatever it may be. And so, in some ways, the threat is out there on the enforcement, but it's not them with their boots on the ground having to deal with the producers, and it's being pushed off on other people who are, crossing their T's and dotting their I's. So that's one of the tricky parts of it. But we know that the 2013 ADT rule, in at least a handful of instances, there were enforcement actions.
With the recent Chevron ruling, is that having any impact on your litigation?
My answer is yes. The government's answer is no. But I will say, we litigate these sorts of cases across the various agencies. I think I have cases suing at least 10 different agencies right now. And the government tends to, when it loses at the Supreme Court, circle its wagons. And we're seeing that post Loper Bright and Relentless, that they're just sort of doubling down and saying, no, that never would have applied to this case anyway. The difficult thing, I think, with this rule is it is a rule that was proposed while Chevron deference was still available to the agency and finalized shortly before the court overturned that case. And so I don't know, but I suspect, having, litigated against the government and many different agencies over the years, that it may very well be that they thought, well, if we get sued, we'll just fall back on Chevron, because that was sort of the go-to for most agencies. So again, my view is Chevron Loper Bright is going to control the way we look at some aspects of this case, and the government's response has been no, it doesn't.
Say, I would like just to do a little bit of clarification. So the 2013 rule, nothing has changed. The qualifications of what needs to be tagged, nothing has changed. I guess I'd like to, the EID button is now the required tag. But the requirements of what needs tagged or does not need tagged has not changed. If somebody's buying cutting bulls out of Fort Pierre and sending them to Nebraska as a feeding animal, they had to be ID'd to go before. They could put a silver noose tag in them. Or if it was a heiferette or feeding animal, if it was over 18 months, they would use the bangs tag. If it didn't have a bangs tag, they would put a silver noose tag in it. So that nothing there changed. There's just no more metal tag. Anything that is required to be tagged is now required to have an EID. There's no new things like anybody ranching. I've had them call, well, gosh, if I'm gonna bring my heifer calves to town, you know, like Staten, do they gotta be tagged before I can sell them? No, nothing there changed. But anything that's gonna get tagged or that's required to be tagged has to have a button now instead of either the orange tag for bangs or the silver tag, which was simply for ID. So I guess if you've got any other knowledge on that, but that is my understanding of the new rule.
No, that is, and all the exemptions and everything stayed the same. And I think, again, that goes to sort of a rollout problem that there's just been a mass confusion, because we get questions all the time like this of, well, are my cows or bulls covered? And I said, well, it's hard, you know, were they covered before is usually a fair question to ask.
Jeff Burry in Moorcroft, Wyoming. Does not Secretary Brooke Rollins have the authority with the stroke of her pen to do away with all this?
Absolutely. It's an agency rule. And agencies regularly, particularly when there's been a change in leadership at the top, have gone back and redone it. Certainly the president has called for systematic review of regulations on a handful of theories, including what comes out from Relentless and Loper Bright, which is this based on the best reading of the statute? And again, you know, us and USDA, as of yet, have a different view. But to answer your question, yes, this could change tomorrow. It just takes the folks in leadership to make that choice and go forward on it. That's it. All right, thank you.